And one of the things I know that comes up often is when you do a medical procedure, a surgeon or surgery or anything like that, part of the intake process or getting ready to do the surgery or whatnot is you're signing a form, and you're signing a form saying you're agreeing to allow them to do what you're doing. What's the consequences of this form that seems to be like, hey, I understand that, bad things may happen here, and does that prevent you from filing a claim? And what is that called, and how does that apply?
So generally speaking, it does not prevent you from bringing a claim. There's a separate cause of action in Pennsylvania called lack of informed consent. The consent form that somebody signs would come into play if somebody filed this lack of informed consent claim. But putting that aside, I mean, if you have a medical malpractice case, which at least in my practice and my experience, I'm not having a lack of informed consent claim. It's just kind of the general negligence, breaching the standard of care case. The consent form doesn't really mean anything. The defense can't use that in the case to say, hey, they can't hold the document up and say, hey, Mrs.
We
Smith
cut we
signed.
cut the wrong leg off, but this means you
Right,
can't sue us for that.
right. Hey, this was a risk of the procedure that we would, chop your right leg off instead of your left.
Right.
Like that can't be used, in a general medical malpractice case. So yes, I mean, it could be an element when it comes to that lack of informed consent claim, but that's it. Other than that, it doesn't mean you can't still then pursue a medical malpractice case. You're not waiving your right to bring a case based upon signing a consent form.